name is Gary Hankins, your narrator. The purpose of this training video is to familiarize you with basic court procedures, the composition of the court system, and how to conduct yourself in court. We will also go over civil depositions and other legal procedures you may be required to testify at. Because every state's court procedure varies to some degree, it would be impossible to cover the court procedures in all 50 states in this short training video. These variations do not pertain to the overall concept. For example, some states have a court of general sessions, while in another state it would be called the circuit court, and still others may call it the municipal court. Your instructor will point out any variation, if any. Let's start with the standard design of a courtroom. For the most part, all criminal and traffic courtrooms have basically the same layout with some variations. First, there is the judge's bench, which is on a raised platform so the judge is able to see everyone without obstructions. There is usually a door to the left or right of the bench that leads into the judge's chambers. In front of the judge's bench, at the lower level, is the judge's clerk. In front of the judge's clerk on the right or left side is the witness stand. The court reporter usually sits in front of the judge's clerk. The court reporter is equipped with a portable stenotype machine. The reason it is portable is that they may move around during the trial. Sometimes they are near the witness stand and other times in front of the judge's bench when attorneys approach for a sidebar. A sidebar is when a legal issue that does not concern the jury needs to be decided. Sidebar issues are always out of the jury's hearing. In many courtrooms, as the court reporter types, it is displayed on TV screens for the judge and attorneys. Then there are the attorney tables, one for the prosecution and one for the defense. They're located facing the judge on the left, the other on the right. The jury box is located on the wall facing the witness stand. There are 14 or more chairs, one for each juror and the others for the alternate jurors. The door to the jury deliberation room is usually close by. There is also a door for defendants who are still in custody to enter and exit the courtroom. Some courtrooms are equipped with closed-circuit TV. TV cameras are never pointed at the jury box. Most courtrooms have a witness room to prevent a pending witness hearing what the previous witness's testimony was. Last but not least is the public area. This area always faces the judge and usually has benches left and right of the center aisle. Now let's briefly go over the participants involved in a trial. The judge, the judge's clerk, the court reporter, the bailiff, the prosecutor, the defense attorney, the defendant, the witnesses, the jurors, and the press. And of course the audience, which many times will include the press. Let's create a hypothetical crime. Throughout this training session, this hypothetical scenario will be used as a model when describing the various court procedures. While you're on patrol, you observe a subject coming from a building on your post. In his hand, he has a laptop computer belonging to your client. You apprehend him, call the police who charge him with burglary. Your apprehension starts a chain of events involving the criminal court system and the criminal court because of the crime committed, the civil lawsuit because the victim felt the crime was preventable. Security officers need to understand the constitutional amendments in the United States Bill of Rights that pertain to criminal procedures. So let's go over them. The Fourth Amendment. The Fourth Amendment protects against unreasonable search and seizures. The Fifth Amendment. The Fifth Amendment provides protection from double jeopardy and self-incrimination. The Sixth Amendment. The Sixth Amendment, the right to a speedy public trial, impartial jury, confrontation, compulsory process, and assistance of counsel. The Eighth Amendment. The Eighth Amendment protects one from cruel and unusual punishment. The 14th Amendment. And the 14th Amendment includes due process. Now let's talk about court procedures. For the most part, court procedures are identical in every state, the District of Columbia, and U.S. territories. Starting with the litigation purpose, trials and hearings are either criminal or civil. They are based on the opponent process. In other words, one side alleges that the other side committed a violation, while the other side denies the allegation. Both sides try to prove that their opponents are wrong by providing evidence and testimony. A verdict in their favor is the goal, and everything else is just a means of getting there. As a security officer, it is your duty to the court, your company, and to yourself to give truthful testimony. A subpoena is an official document issued by the court to appear in court at a specific time and place and to provide testimony. A subpoena may also require you to bring documents, such as your incident report and notebook. Subpoenas are either hand-delivered or mailed using signature-required certified mail. Failure to comply with a court subpoena is a criminal offense. You can be charged with contempt of court, which carries a penalty that could include jail time. So it is important to you that you always respond to a subpoena. If the date to appear on the subpoena conflicts with something important you have scheduled for that day, notify the court immediately. After your burglary arrest, the prosecutor will hold a probable cause meeting with you and the police officer. This meeting is sometimes called the prosecution hearing. It is to see if there is sufficient evidence to go forward with the trial. This meeting is not as formal as court hearings and trials. If the prosecutor feels there is sufficient evidence to proceed to trial, they place the case on the court docket. The court docket is a list of all the pending trials that will be assigned to a judge. When a judge is assigned, a pretrial hearing is scheduled. A pretrial or preliminary court hearing is conducted in front of a judge. It requires the state to prove that a crime occurred and that sufficient evidence exists to prove the defendant committed that crime. The judge decides based on the evidence presented if the case should go forward to trial. Pretrial testimony requires the same rules as a regular trial. The difference is that there may not be as many witnesses and there is no verdict. In most misdemeanor cases, there is no pretrial hearing, so you will only have to testify during the actual trial. In serious felony cases and some misdemeanor cases, you may be required to testify at the pretrial hearing and then again in the actual trial. Depending on the state laws, some trials are heard by a jury and others with only the judge. This is usually based on the severity of the crime. The most severe crimes must be heard by a jury. Those less serious crimes can be heard by the judge or the jury. The option of having a jury trial or a trial by a judge is up to the defendant. There are also minor criminal offenses that a jury is not allowed. Only the judge can preside. Another hearing you may have to testify at is the grand jury. Depending on the jurisdiction, the grand jury can have 21 grand jurors or even more. The grand jury is always conducted behind closed doors and is not open to the public. A prosecutor presents evidence to the grand jury and acts as its administrator. Only one witness at a time is allowed in the grand jury room. Only the prosecutor and the grand jurors may ask questions of witnesses. Witnesses testifying before the grand jury may not be accompanied by an attorney. Jurors are selected from the jury panel. The jury panel is a large number of citizens assembled at the courthouse. When the case is ready for trial, the jury panel is brought to the courtroom to sit in the audience section. The judge will ask the potential jurors several questions. For example, if the jurors have a problem hearing a burglary case, if they know the defendant, the police officer, the security officer, any of the attorneys, the judge, and so forth. The prosecution and the defense each are given a number of preempts. A preempt is the legal name used to describe the procedure where the prosecution and the defense attorney can tell the judge to strike that juror. In other words, they do not want a particular person on the jury. When they preempt someone, they do not have to give a reason. The number of preempts each side has are based on the severity of the crime and the state law. Once the jury and the alternates are selected, they are sent to the jury room. The prosecutor and defense can present their motions to the judge out of hearing. When the jury comes back into the courtroom and is sitting in the jury box, the prosecutor and the defense attorney present their opening arguments to them. Incidentally, it is not required that the defense give an opening statement. Because it is the prosecution's burden to prove that the defendant committed the crime, the prosecution always presents their case first. The defense then presents its case. Again, they do not have to call any witnesses, nor does the defendant have to testify. In your burglary case, you and the police officer would more than likely be among the first to testify. Before you can take the witness stand, you have to swear under oath to tell the truth. You are first questioned by the prosecutor. When the prosecution finishes questioning you, the defense attorney can cross-examine you. Notice I said can. The defense is not required to question anyone. Here again, the rationale is that it is the prosecution's responsibility to prove the defendant guilty. After everyone involved has testified, the prosecution and defense present their closing arguments to the jury. After the closing arguments, the judge will give the jury instructions regarding the procedure for deliberating and other legal issues. The jury then goes into the jury room to deliberate. When they come to a unanimous decision, they notify the bailiff, who then notifies the judge. When they come back into the courtroom, they will advise the judge of their verdict. If the verdict is guilty, the defendant can be sentenced at that time or sentenced on a later date, which is called the sentencing hearing. If the defendant is found not guilty, he is released. The prosecution and the defense have the right to appeal the decision. If the defense attorney appeals the guilty verdict to a higher court can reverse the decision, concur with the decision, or require a new trial to be held. If the higher court hands down a reversed decision, the guilty verdict against the defendant is thrown out and he is set free. If the decision handed down requires a new trial, you may be required to testify again. Of course, if the higher court concurs with the lower court, the defense attorney can appeal to the next higher court. In some cases, this can go all the way up to the Supreme Court. Now we need to talk about your responsibilities and requirements in the trial process. Starting with your appearance, as the old saying goes, the first appearance is a lasting appearance. This could not be more accurate when testifying in court. Remember, you are not only representing yourself, but you are representing the prosecution's case, your company, and your company's client as well. Sometimes Even though you're telling the truth, your impression is taken into consideration when the viewer is deciding whether you appear truthful and sincere. Some other inappropriate images you should avoid is wearing excessive or inappropriate jewelry, chewing gum, or wearing sunglasses while in court. For men, the best dress code for security officers in court is their uniform. If not in uniform, the dress code should be as conservative as possible, such as a business suit, suit jacket, clean shirt with a collar, and trousers. T-shirts and sweatshirts just won't cut it. For women, a pantsuit or casual dress may be appropriate. Shorts and see-through blouses would not be proper attire. By demeanor, we are talking about your behavior and how your personality comes across. As a witness, you are under scrutiny by the judge and the jury during the entire trial. Your demeanor will reflect how the court perceives you as well as how professional a security officer you are. Always avoid any loud comments while waiting to testify and talking with other persons while in the courtroom. When testifying, always remain composed, mature, and speak clearly in a professional manner. Avoid any leering looks at the defendant or any others related to the case. This will be seen as a form of disrespect or bias toward the defendant. The best approach is to remain neutral by showing no visible emotions for or against anyone during the proceedings. Always control your emotions concerning the defendant or the case in question. Control your body language to avoid sending any negative signals. Some examples are slouching, arrogantly leaning back in the witness chair, elbows on the desk with hands under your chin, to name just a few. When you are sitting correctly in the witness chair, stay relaxed and remain calm. When you are asked a question, look at the person asking the question and continue to look at them when answering the question. The only exception would be if the prosecutor or defense attorney says to you, "Tell the jury what you observed." In that situation, you would look at the attorney while a question is being asked and then turn towards the jury or judge when answering it. Before you arrive at court or a hearing, review your notes and reports concerning the matter. Always ask the prosecutor if you can or should testify from your notes. The reason is that if you testify from your notes, the court will allow the defense to see them, giving them additional information to attack your memory and your credibility. Always address the judge as "Your Honor." Stand when he or she enters and leaves the courtroom. Remember, it is not the person you are being respectful to, it is the position he or she holds. Only answer the question asked. Do not elaborate. If the question requires a yes or no answer, answer only with a yes or no. The prosecutor should object if he or she feels the question is vague, improper, misleading, or irrelevant. Make sure your response always answers the question. Again, never elaborate. Never answer too quickly. Pausing before you answer the question gives the prosecutor time to object to improper or misleading questions asked by the defense. If you're not sure what the attorney meant by his question, don't guess what you think he meant. If you don't understand, say so. Ask him to explain what he meant. Usually, the judge will make the attorney explain if he refuses. When testifying, try to be as accurate as you can. Again, if you're not sure, do not elaborate. Just testify to what you remember. Avoid excessive responses to questions. Keep your answers short and to the point. Answer all questions truthfully, whether they are favorable or unfavorable towards the defendant. If either side makes an objection, immediately stop answering the question, even if you are in the middle of a sentence. Wait until the judge rules on the objection. Many times, the prosecutor and defense attorney will sidebar with the judge regarding an objection. When they are done with the sidebar, and if they do not repeat the question, ask them to repeat it for you. Speak loudly enough so that all the jurors, both attorneys, and the judge can hear you. This can be accomplished more easily by sitting straight with your face about 6 inches from the microphone, if one is available. Things to avoid. Do not display any sign of prejudice or overzealousness. Do not argue with the defense attorney. Do not joke or act silly in the courtroom, even when the judge and jury are not present. If you do it while the court is in session, the judge could hold you in contempt and fine you, or worse, have you arrested. Failing to look directly at the person asking you the question. Do not make it obvious that you are stalling answering a question. If you're not sure what the question means, don't ask the district attorney. Always ask the judge. Your Honor, I don't understand the question. Should you inflate your qualifications or experience, that would be a lie and is subject to a perjury charge against you. Never offer an opinion or a conclusion unless you are asked to. Just answer the question. Do not give the appearance that you came to court unprepared to testify. Being late to court, especially if you are late for your testimony, gives the jury and judge a negative impression of you. By law, the defense attorney is obligated to provide his client with the best possible defense, regardless of his guilt or innocence. Here are some of the tactics that they may use to meet that goal. They will attempt to break down your testimony by vigorous cross-examination. They will question your memory. They will attack your credibility. The defense wants you to provide information different from what you told the prosecution under direct examination. This is so they can show the jury and the judge that there are inconsistencies in your testimony. They will attempt to make you nervous and try to make you make the mistakes. Just remain calm and provide the same information to the defense as you did to the prosecution. The defense attorney may act friendly, but they're actually attempting to win you over so they can trick you into making a mistake so that they can discredit you and shed doubt on your testimony. In the United States, there are more than 51 different versions of the court structure. Each of the 50 states has its own rules and procedures. The federal courts also have their own rules, which are occasionally interpreted differently in different parts of the country. However, for the most part, they are all very similar. The systems are generally a 3-tiered one. Your burglary case would be brought before the lowest level court. Once a verdict or judgment has been made, both the defendant and the prosecutor can appeal the decision to an appellate court or court of appeals. In other words, if they do not like what the judge and or jury decided, they can complain to the next higher level in the court system and try to get the decision reversed. However, they can only appeal if they believe the judge made a legal error, not just because they are disappointed in the outcome. At the appellate court or court of appeals level, there usually is a panel of 3 judges who hear arguments on both sides. Judges at the appellate court can usually only decide matters of law. In general, all of the facts in the trial record are assumed to be true. The appellate court has 3 options. It can decide the judge was wrong. It can order a new trial, or it can concur with the verdict. Again, If either party to the case does not like the decision by the Court of Appeals, again, there must be a legal error in the lower proceedings, they can appeal to the highest court, usually called the Supreme Court, composed of 9 justices. All 50 states and the federal courts have some version of a Supreme Court. The Supreme Court decides issues in the same manner as the appellate court. However, there is no court higher than the state Supreme Court to which to appeal. The judgment of the state Supreme Court is final, with some exceptions, and that is when it is appealed to the United States Supreme Court and they are willing to hear the case. Let's go over the court structure again. You have the lower court, the Court of Appeals or appellate court that can reverse or remand the verdict for a new trial. And finally, you have the state Supreme Court that has the final say. The United States district courts are the trial courts of the federal court system. There are 94 federal judicial districts, including at least 1 district in each state. These courts hear federal cases. A few of the federal cases you would most likely be required to testify in are felonies, some misdemeanors, civil trials, jury trials. The 94 judicial districts are organized into 12 regional circuits, each of which has a United States Court of Appeals. The Court of Appeals courts hear appeals from the district courts located within its circuit. The United States Supreme Court consists of the Chief Justice of the United States and 8 associate justices. At its discretion and within guidelines established by Congress, the Supreme Court each year hears a limited number of the cases it is asked to decide. Those cases may begin in the federal or state courts, and they usually involve important questions about the Constitution or federal law. Depositions are another legal process you may get involved with. A deposition is testimony given under oath and recorded for use in court at a later date. It is part of the discovery process in which attorneys gathering information for preparation for trial. Let's use your burglary case as an example. Assuming the defendant was found guilty in the criminal trial and your truthful testimony helped to convict him, the client could still sue your company for failing to prevent the theft. This is a stretch, but happens very often. This would be a civil lawsuit requiring all parties involving give depositions at a hearing prior to the trial. Depositions are almost always conducted in a meeting room at a conference table. The number of chairs required depends on the number of participants. The court reporter usually sits near the conference table. The defendant, this is the person, persons, or company being sued. The complainant, this is the person, persons, or company suing. Defendant's attorney, the complainant's attorney, the court reporter, the witness. On very rare occasions, there is a judge presiding. A deposition is important and is not something to be laughed off. Giving false testimony at a deposition, just like in court, can result in charges of perjury and obstruction of justice. At the deposition, you will be put under oath, just as you were in criminal court. Lawyers can ask you a wide range of questions relating to the case. The lawyer's questions and your answers will be recorded by the court reporter. In some depositions, they also tape record and/or videotape your testimony. In the burglary scenario, the lawyers will have the transcript from the trial containing your testimony. That testimony will likely be used to cross-examine you. If your testimony at trial varies from the testimony you are now giving, it could damage your credibility. For example, the lawyer for the other side says things like, "Was your memory better then or better now. To help avoid this, always ask to see the transcript of your testimony from the trial before testifying again at the deposition. In most depositions, you will be giving testimony in a case that stands on its own with no prior litigation. An example would be someone who is suing your company for failing to have a security officer on duty at the time the contract required one. If for any lawful reason a person who testifies at a deposition is not available at the time of trial, the deposition testimony given at the criminal trial generally may be used as evidence. At depositions, the witnesses or party may be required to bring specified documents and records and allow for counsel to the parties to review them and to ask questions regarding them. For example, if there is an issue about where you were at the time of the burglary, the plaintiff's attorney may require you to bring your incident report and notebook. This is so that you or they can refer to it, refresh your recollection, and it makes it harder to say, "I don't remember." All witnesses at a deposition have the right to have their own lawyer present. Your company's lawyer will in almost every case protect you while they are protecting your company's best interests. The company will tell you that if you do not understand the question, ask for clarification. Your lawyer may object to questions that are vague, improper, misleading, or irrelevant in that they do not relate to the specific case. In addition, at the end of the questioning by the other side, your lawyer can ask you questions to clarify or better present your side of the story. The purpose of a deposition is to gather background and evidence and lock in the stories of the parties and the witnesses. By getting all the facts which the person may know down on paper and obtaining whatever helpful admissions are possible from the other side, lawyers can better prepare the case for trial. The lawyer for the other side will also use the deposition session to evaluate how you are likely to appear in court. Will you, in their opinion, appear likable and believable, in command of the facts and able to express yourself clearly? Or will you come across as untruthful, defensive, evasive, or arrogant? Here again, we need to stress the importance of your demeanor. There is never a jury present at a deposition, and the number of times a judge is present is very small. After the deposition is over, the court reporter will provide a hard copy of the transcript with all the witnesses' testimonies. Both attorneys will receive copies. You then will have the opportunity to review your testimony. If you see an error regarding your testimony, you can request that they make the corrections. Generally, the reporter's word will prevail as to what you actually said, because they have the recorded statements you made. Your deposition can go a long way in assisting your company's case in the litigation. This concludes this training session. If there was anything in this training video that conflicts with your state laws, your instructor will clarify it. Remember, always be truthful and appear respectful. Thank you.